Committee Room 30, signed. 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 Committee Room 30, Sound. 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 Committee Room 30, Sound.
To the public. I welcome members to the 67th meeting of the Committee for Justice. Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of this meeting. Can I advise members that it is proposed that the oral evidence session with the Chief Constable and Sir Iain Livingstone on Operation Kenova and Operation Denton will be recorded by Hansard, and can I seek your agreement to this? Members agreed? Agreed, yeah. Can I remind members then that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. Any members who have interest to declare in relation to the day's business should do so now or when the particular matter arises. So can I ask if members have any interests to declare?
Would there be, apart from being on the access to justice?
Access to justice, APG, okay, as most of us attend that. Brian?
Chair, just in terms of the Kenova report, whilst it's not in on our agenda specifically, I feel it should declare an interest. Operation Terma, which is included in the report, and the murders of 3 RUC officers, includes Constable Paul Hamilton, who is a relation, the brother-in-law of my mum's cousin. So I feel I should honour his memory and his service by declaring that.
Okay, no problem. Okay, agenda item number 1 then is apologies. I've received apologies from Patsy McGlowan. Any other apologies? I don't think so. I think we're all here then. And there's nobody attending the meeting today virtually with regards to members. Agenda item number 2 then is draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday the 5th of March are at pages 5 to 14 of the meeting pack? And I advise members that there has been a minor editorial change at page 12 in the pack to reflect that the committee had agreed to write to the Minister of Justice, the Chief Constable and the Policing Board about the Ombudsman's report on abuse of position for sexual purposes by the PSNI officers. Can I ask members if they are content that the minutes are otherwise a true reflection of the proceedings of the meeting held on the 5th of March? Members agreed then, I sign.
Yeah.
Okay. Thank you. Agenda item number 3 then is matters arising. Can I refer members then to pages 16 to 20 of the meeting pack for the relevant papers on the Department of Justice Crime and Policing Bill, 3rd Legislative Consent Memorandum. Can I remind members that at last week's meeting, members noted an update from the Department of Justice providing details of its proposal to bring a 3rd LCM in relation to provisions within the Crime and Policing Bill, following amendments tabled for Lord's report stage, which applied to Northern Ireland. Can I inform members that the committee has now received confirmation that executive agreement has been secured and the department will therefore bring forward a 3rd LCM in respect of the age verification requirements for online sale and the delivery of knives and crossbows. A copy of the memorandum that has been laid the Assembly under Standing Order 42A9 can also be found at pages 17 of the meeting pack. The debate on the LCM has been scheduled on the order paper for the 16th of March, which is Monday. Can I remind members that it was agreed last week that the committee will not produce a report on this LCM, but I will speak briefly to the motion in my capacity as chair of the committee. Can I ask members if there are any other matters arising from the minutes that they wish to raise at this stage? No? Okay, can I refer then members to pages 22 to 187 of the meeting pack, where members will find a copy of the Kenova final report, Northern Ireland Legacy Investigations and Reviews. Part B of that report covers Operation Kenova Steak Knife, and Part E covers Operation Denton, the Glenanne series. Can I inform members that the witnesses providing evidence today are John Boucher, the Chief Constable of PSNI, and Sir Iain Livingstone, Officer in Overall Command of Operation Kenova. You're very welcome to the committee, gentlemen. Thank you very much for your attendance and for your time that you're taking here with us today. I'll let you get settled, but I'm sure you have an opening statement. Chief Constable, would that be right?
I'll make a few opening remarks if I may.
Fine, that's no problem. Okay.
Thank you. Well, firstly, I'd like to thank the committee for inviting us to speak to you today around the workings and the findings of Operation Kenova. I think it'd be remiss of me not to acknowledge the victims that Kenova has engaged with and to recognise their fortitude and bravery in coming forward to speak to the inquiry. Each and every one of those families across a myriad of investigations that ultimately Operation Kenova amounted to all have incredibly tragic stories. There's no monopoly on grief in Northern Ireland and with regards to Troubles, and it's thanks to them and their coming forward and their persistence and the way they behave with real dignity that I think is one of the critical success factors to how Operation Kenova managed to achieve so much. I also want to acknowledge the independent groups that we introduced to help as oversight and governance groups to make sure that Kenova operated and performed as well as we possibly could, and in accordance with Article 2 of the European Convention of Human Rights, and the team who did the work. But I do very much also want to thank Sir Iain Livingstone, because Kenova is something that's vocational. It's a commitment that everybody involved in it made to the families. I could not have left Kenova unless Iain Livingstone had agreed to take over, because he'd been involved in the entire journey as a member of 2 of those governance groups. And outside of Iain, there was nobody else who could have picked up the reins for the role. So I do owe a debt of gratitude to Iain for undertaking that, which wasn't a straightforward decision for him, I know. And again, probably just finish on the fact that I know many of the victims who engage with us have now got information that they otherwise would not have had, and just again to really pay tribute to them with regards to how they assisted the inquiry. Thank you.
Okay, thank you very much, John, for that succinct and brief presentation. It's always welcome whenever visitors come and give that brief synopsis and not lead on for 15 minutes of a statement, because we can get straight down into questions then. So I thank you very much. So Iain, do you want to say anything at this stage? Are you okay?
Yeah, just to thank you for the opportunity to come here today as well, and just to reiterate John's remarks about the focus on victims and families. I truly believe, with decades of police and service, that that's what distinguishes Kenova under John's leadership and under the many people that worked on it, was in a very complex environment, trying to put the interests of victims and families at the forefront. And that, I think, is something, as Kenova ends, as inevitably it must, that whatever comes next, I would just underline that principle and that ethos has to be retained going forward. So thank you, Chairman, and thank you for the invitation to be here today.
Thank you very much. I'm going to put it out straight to members. So Emma, Deputy Chairperson.
Thank you, Chair, and thanks to you both for coming in. You've outlined both, I suppose, in the report and in your verbal remarks individually today, the importance of victims and survivors and families, and how critical the engagement with them was in this process. I suppose it's a concern for all of us that we can see the fact that information was withheld, which impacted on the report, and the, I suppose I would call it, obstruction from security forces and MI5 in terms of information that was not released until it was too late to secure prosecutions. And we know that a lot of the victims' families have concerns around the current legacy, both the 2023 Act and the current legacy legislation that is going through in terms of the repeal of that Act and whatever replacement we see. So I suppose my question would be how you feel we can learn lessons from how the neither confirm nor deny policy was implemented, and the impact that had for victims, survivors and families in terms of Kenova.
So thanks, Iain. I'll go first on that. And there's a lot in the remarks that you've just made that I'll try and deal with, because it's not straightforward. In the interim Kenova report, there is a section, I think it's page 144, forgive me if I've got that wrong, whereby I reflect on comments made to me by others that had undertaken legacy inquiries before Operation Kenova. One of those that is quoted in that section of the interim report is John Cox. John Cox headed, forgive me, the historical inquiries team that was set up by Sir Hugh Ord. The second person that I reference and quote at that section of the report is Lord Stevens, John Stevens, who did a number of legacy inquiries here. There are 3 Stevens reports. I also reference a judge, a Canadian judge, who worked as the senior legal advisor and in effect the deputy to Judge Corey, who did legacy work here. That's Rennie Pomerance. And finally, there's a barrister who supported the Smithick inquiry, Mary Laverty, who is referenced in that part of the report. Now, the reason I've just taken you to that is each of them talked about the obstruction, the challenges, the lack of transparency, and some of their remarks are incredibly powerful. John Cox said that he was not given all the information that he asked for within the PSNI. Lord Stevens says he was obstructed. He was criminally obstructed. He was not given the intelligence that he should have been given. Mary Pomerantz talks of the challenges of the environment in which they were placed and says that the security agencies considered themselves above the law. And Mary Laverty, who worked at Judge Smithick, said, when will they consider things are no longer protected by national security? I spoke to all of the people who ran those inquiries. Lord Smithick has now passed away. Obviously John Stevens, both Iain and I have a lot of dialogue with. Spoke to John Cox and Rennie Pomerantz, and also Sir Desmond de Silva, who did an inquiry here into the Pat Finucane murder. And they all described these obstructions. Now, in my policing career, which is now 43 years, and almost all of that's been as a detective, and every day is a learning day, I'd never experienced anything like that or realised the challenges in getting information with regards to legacy cases. But I then want to put a bit of context into that challenge. These were incredibly difficult times. Society had completely broken down, and the security forces were doing everything they could to keep society safe. In many instances, I think the rule of law had escaped what the security forces could effectively deliver. And it was such a unique and difficult time. A number of things, I think, and Operation Kenova provides some of the findings for this, occurred that would never ordinarily happen in any of the security forces. And because of these things that have been examined by those other inquiries in the past, I think there was a cultural resistance to enabling those inquiries to get to the bottom of what had happened. I would hope, as we get ever further away from the Troubles, from the conflict, attitudes, and I think they are changing, I think Kenova is an example of that, have changed to a point where we are now able to get information that previously, Operation Kenova certainly did this, has never been provided. But there remains some resistance. And there remains some hangover from that period of time that I'm dealing with now around public interest immunity issues, around how we disclose sensitive information, how we deal with it. You mentioned neither confirm nor deny, NCND. The totemic approach of NCND in a way as ex-head of covert policing in the UK, ex-head of undercover policing, I've not seen elsewhere, but it's applied here in an incredibly strong way because of the legacy of the past. And the more we can do, I think, to address that, and I think the Kenova report with the recommendations, we call for NCND to be reviewed by the Cabinet Office as it's been applied in Northern Ireland. The more that the lessons learned from the inquiries I mentioned and Kenova are applied, the more confident I think victims can be, and the better the Legacy Commission will be in delivering the truth for families. But that doesn't happen simply by attitude. That needs legal structures in the bill to make sure that the information that those families deserve is legally provided for in the Legacy Bill. And to make sure that things that have happened, such as those quotes in the interim report, do not happen, and families feel that they are getting the information that they both legally and morally deserve. So it's not a straightforward thing, but I think we're on a line of progression, and I am hopeful because this bill has to succeed. Legacy, we're at a point now where it feels like last chance saloon to a certain extent because of, you know, the ages of people. We've lost so many during Kenova victims who've passed away. We've really got to get this right. And I just think if we all give a bit, I think there's every opportunity that that can happen.
Chair, if I can come back in. So thank you for that and for how forthright you've been in terms of the obstruction that was faced. And I know that that's consistently been what you have said, and your desire to see the neither confirm nor deny abandoned, and how important that is going forward. You've outlined there your belief that this culture existed as a result of the conflict, and I would contend that the conflict existed because of the culture, and that was reversed. But I suppose going forward for families, I know and I appreciate that you're on the record saying that you believe a public inquiry should be granted to the family of Sean Brown, who was murdered in my constituency when I was just a child, and I know that the family have been very clear in calling for a public inquiry there, and have stated very clearly that they don't believe the current mechanism is going to serve them, and we see the use of PAA there. So I appreciate, and I think it is important that with everything you've said, the power to compel, you're talking there about a desire to see a lack of obstruction, but the legislation has to compel the security forces to provide that information, because history has taught us that without that they will not provide that information.
So just a couple of things. Firstly, you mentioned about NCND. I have applied NCND more than anybody I know. So I'm an advocate for NCND, but every case has to be done on an individual basis. It shouldn't be applied in a blanket way. It's become this high stone wall to stop information being even provided to investigative bodies such as those that I've mentioned, whether it's the Corey inquiry, the De Silva inquiry, the Stevens inquiry, the Het work. We know, and we know from Operation Kenova, that information that should have been provided was not provided to those inquiries. What I'm saying is that has to stop. So all of the information that's available for anything that happened to anybody in any troubles-related case should be provided to the Legacy Commission. Now, there's an interesting element to there was as I describe it, the legacy bill that the previous government introduced and the Troubles bill that this government is introducing. Schedule 4 of the Troubles bill, the newer bill, mirrors Schedule 8 of the previous bill. And what it asks is that all the organisations that hold information, the PSNI holds a lot of information, have got to go through an exercise where we examine that information and we provide a classification of that information, how sensitive it is. And we have to do a second thing, which is to decide or give an opinion on whether that information is prejudicial. Now, all I've ever really been is a detective. There is no other area that I can think of any investigation in any type of crime, whether it be financial or offences against people, sexual offences of any kind, where any organisation that might hold information is asked to do that. They just have a legal obligation to give unfettered access to any information. And then it's for the Legacy Commission, with the proper structures in place, the proper security mechanisms in place, to have access to all of that information so that they can properly investigate that case. And it's for them then to decide what information, and I think they should do it in partnership with the organisation that originally held that information. There should be a relationship there to decide, and the Legacy ICRR is led by an ex-Lord Chief Justice, to decide what can go into the public domain.
You see, in the report it outlines very clearly how the information that was brought late by MI5 that was beyond the scope then of the Kenova report because the deadline had passed.
Yes.
And that in some other circumstances that sort of admission would potentially lead to criminal repercussions. But there was no, unless I'm mistaken, there was no repercussions for that, whether it be a mistake or a deliberate mistake. And I suppose the consequences of that is that we know and we can see in Denton how there was collusion in the north, and families and loads of people within society have known that for a long time. But that then furthers the belief that is still ongoing and that the state's still aiding in that?
Listen, none of us would have wanted, and I must bring Iain in on this because this was during a period that Iain had taken over the stewardship of Kenova. None of us wanted to have had this revelation about this material that we weren't able to consider from an investigative perspective with regards to any inquiries it could have provided us with undertaking. And it really had a significant impact on the trust and confidence of families in the institutions across the security forces, across government, because of the 11th hour nature of it. There was, MI5 did commission an internal inquiry into what had happened. Iain, I know, met with him, and I do need to bring him in here because he managed that issue. But that is a situation that we have to avoid in the future with regards to the Legacy Commission. And my view, by the way, it's an important one before I hand over to Iain, on the material that the PSNI hold, and a lot of it is very sensitive, my view is that Schedule 4, with regards to those two tests, if you like, that the legislation asks that we undertake, should be taken out. And we effectively give the keys to all of our databases with an explanation that that's a sensitive database, that's non-sensitive. We give all of that material to the Legacy Commission. And it's for them then to deal with that information. Otherwise, the optics of it is families will say, so what's happening now with my case? Oh, we're just waiting for the PSNI to decide what's sensitive information, what isn't sensitive information. That's not a good look. We're just waiting for the PSNI to decide if this is prejudicial. That determination, the best placed people to do that are not the PSNI. This is material from many, many years ago. It's from the body that's going to investigate that case that information is relevant to. And in my view, that is an additional element that's been introduced to the bill. I'm sure it's come from government lawyers, that is unhelpful and will impact negatively on the trust and confidence of victims across all victim profiles, across all victim genres. Can I bring Iain in on the matter with regards to the MI5 material?
Thanks, John. Thanks for your question. Maybe just a couple of, well, three perhaps observations, if I may. On NCND, I mean, our position is not that we should abandon it. Just for absolute clarity, our position is it's the application of NCND, particularly within Northern Ireland, and particularly in regard to the agent stake knife, that requires review. So, as John said, the necessity of NCND to protect sources for the greater public good is something that's well established. So it's the application of that principle and doctrine that is the issue that we have. Secondly, the late discovery by MI5 of the material was, I hope that I didn't understate that in the final report. That was a significant error and failure on the part of the United Kingdom Security Service. What I would say was that the leadership recognised that. Once that came to light, they immediately allocated resources, and there was a very thorough search to provide that material. But nevertheless, given the timing of it, when Kenova had been running for 7 years or so, where the non-prosecutorial decisions had already been issued, where we were just about to get implementation of what was then the Legacy Act, the timing could not have been worse in terms of the confidence of victims and families. And to be candid, it had a big impact on us in Kenova as well, because we in Kenova, John had, and we had said to victims and families, we'd said to public representatives such as yourself and other key stakeholders, we have seen material that other people have not seen. We have gone to places that previous investigations haven't, and therefore our judgment is based on that material. And yet here we have all this new material coming to light. So inevitably that then has an impact on the trust and confidence of what our assertions have been. And then the third point is you do take it, you mentioned Denton and other investigations. So while the non-disclosure or the late discovery from MI5 related to steak knife, it did have an impact on our other work, where legitimately people would say, well, you weren't given that material in regard to steak knife, so how certain can you be that you have actually seen everything? And candidly, that's a legitimate concern, and it's a concern that we have. What I do think that we have seen far more than anyone else has seen, and thereafter we can only make our assessments and make our judgments based on the material that we've seen. And then just in closing, it's just to reiterate the point that the Chief Constable, I think, was making very strongly and eloquently there, is that the people who access to information is crucial to an independent investigation, and the people best placed to assess the relevancy of that information are the people carrying out the investigation. And that's a core principle. John, as the Chief Constable of the PSNI, gives an undertaking. That's something that he would be prepared to do. I will decide if I'm investigating what I need. You won't decide what you're prepared to give me if you're being investigated. That's the core principle.
And just one final question, if I may, because you've went through that process. Were there consequences for those who were, when you talk about an internal investigation as to how that information was missed or how it wasn't presented until it was too late?
Well, I know there's certainly, again, this relates to material from decades ago, as John has already outlined. A lot of the internal practices and processes of MI5 have changed significantly since then. In terms of individual consequences, a lot of the individuals who were involved in some of those matters are retired, and in some instances long retired. So MI5 has undoubtedly, and I don't think have tried to be equivocal on this point, have undoubtedly recognised their failings, and I think they've taken steps to improve their information handling.
Recognising failings and feeling the consequence of that are two different things, and I suppose the perception, my belief is that that was a direction from the top down, and for that to have gone then sort of acknowledged but unchallenged effectively would probably further that belief, particularly.
I haven't seen anything that would support your belief that it came from the top down. And my judgment on it was that this was definitely within the security service. I think there was a culture of reluctance at times that could border on obstruction. There was a sense of why this police team, Kenova, now come and asking hard questions many years later. My own view is that wasn't a view that was held by the leadership of the security service, but there was undoubtedly an element within the service that made it very difficult. And John articulated those challenges, those difficulties in his interim report, and I mention them in the final report as well. So in no way, shape or form are we diminishing them, and I think we've actually shone a light on them in a way that hasn't been done previously. But my own view is that I do think MI5 have taken the learning and the experience of Kenova and taken the lessons on board.
Thank you. Okay,
Connie?
Thank you both very much for coming in today, and I was really heartened to hear in your opening remarks the real focus on victims, and I really want to ask around that and ask around how you engaged with victims throughout your process, how you ensured that they were communicated with and had confidence in the work you were doing, because that's obviously such a crucial part of that process, and any learnings we have from that, but then also how you understand the victims feel by not being able to have steak knife named in this report. I think you've both been quite firm about that, but how the victims feel, and from what I understand, it does feel like a bit of a slap in the face, and as you said, Chief Constable, I think he used the word farce at the time.
So with regards to the victim focus, I was asked to do this inquiry by Sir George Hamilton when he was Chief Constable. Interestingly, everybody I spoke to about whether I should do this inquiry, because as anybody might expect, I sought advice from people, including John Stevens, because as an ex-commissioner I knew him, I was in the Met for a very long time. And everybody told me not to do the inquiry except John Stevens. which I found interesting. In fact, my wife said, I wish they'd tell you to do the inquiry because you might be less interested. There are challenges here that I did not understand. I really didn't. I thought I was fairly well read, learned. I've been a detective throughout my career. I'm an operational cop. Coming here was an entirely new operating environment. And many of those families that I referenced in my opening remarks had tried to get information about what happened to their loved ones. And the very institutions who are responsible for giving that information had turned a deaf ear to them, and in fact on some occasion had obstructed them in getting that information. There was no framework then for dealing with legacy. There was these ad hoc inquiries. Different people at different times had done different things. I realised that if we were going to get any real progress with any investigation, the main constituency that I needed to get the confidence of was these victims. And by the way, when I went to meet them for the first time, most of them were extremely angry and upset after many, many years of frustration. And that includes families from, and it's important I say this, across all the different victim sectors, security force families. So we spent a long time, and it was valuable time, in listening to what they had to say. Now, that exercise of listening was incredibly valuable for a number of reasons. Firstly, it showed them that we respected them and wanted to know what they had to say. Most of those families have become subject matter experts in their particular family member's case. They had the files from the inquest. They had the HEP report. If there'd been any type of examination through some of those inquiries that I've just mentioned that touched on a number of different cases, they would have had material from those inquiries. They would have their lever arch files of information. They're an incredible source of intelligence. Unfortunately, in the absence of a proper framework to deal with legacy, whenever anybody commented on what had happened in their particular case, because they had nowhere to go to test that theory or that claim, there was also lots of misinformation that existed with those families. But from that initial listening exercise, acknowledgement of what they'd been through, acknowledgement of what they had suffered, provided us with a number of things: the trust, the confidence, the beginnings of those sorts of relationships that you need with victims, so that actually others will come forward and give you information that they know. It also, very importantly, gave us information that I think otherwise, because they'd not been spoken to, and a number of the cases, particularly the steak knife cases, they were there. They had a knock on the door. It was their neighbours that witnessed things. So they were able to tell us and point us to where to go. And if we hadn't had that trust and confidence, we'd have missed on a whole area of critical evidence. So we, as you might expect in any ordinary investigation, made sure that it was an entirely victim-focused process. And what we also did, by the way, was bring in experts who have been part of processes and learnings around dealing with really significant instances where there's been learning that investigations should know about. We put together a victims focus group, and that group would check what we were doing and advise us with regards to how we were undertaking and conducting that investigation. That group, when they asked for it and if the victims agreed, would go and meet the victims that we were dealing with to check with how the experience was for the victim. Were we meeting them regularly? And there were so many stories from previous inquiries where they had met people and then never heard from them again. So we put together as much as we could in the structure that we could find. And by the way, we took the learnings from those inquiries I've talked about, those previous legacy inquiries. I went to see all of the people who did those inquiries, and I said, what worked? what didn't work, what should I guard against. And we applied, I was working in the counter-terrorism world for many, many years, and organised crime, the model, the structures of a modern investigative capability. So we brought those together. And that was the investigative model that we created, which is Operation Kenova. So it was a hybrid. And by the way, to assure victims that we were doing this as well as we could, we had the victims focus group, which would ensure that we were doing everything we could around the victims element. But we had other groups. We had an independent steering group. This was a group that Iain was on, with incredibly well-respected senior investigators from across the world who dealt with really complex, very, very notorious inquiries to make sure that when we were undertaking our inquiries, we had a group of people, almost like a star chamber, saying, have you considered this, have you considered that? And again, that group would meet stakeholders, they would meet victims, to assure them about what we were doing. And the reason we put those layers in place was because previously there was such low levels of trust with regards to any type of investigation. So that was the sort of approach around the victim-focused element. And even now, and I don't do this as well as I wish I could, but I will speak to victims on anniversaries or key dates. I was with 3 families this week for dinner, bereaved police officers' families around the Kinnigo embankment incident in 1982. So we keep that relationship, so we're still answering questions and making sure, because in that particular case, there's an ongoing criminal prosecution. So just doing the right thing around those victims in the way that you would have expected us to do anywhere else in the United Kingdom is the approach that we've done here. There was a second element to your question beyond the victims. What, just remind me, sorry.
The impact that you felt not being able to name Steak Knife had on victims, and how that made them feel.
So obviously that issue is still unresolved. I want to make that point. I wrote, for the information of this committee and others, I wrote to the Secretary of State recently a very detailed letter setting out why he should set aside NCND in this particular case and identify the agent Steak Knife. I think the decision is still being taken around that. But the impact, because I had expected and hoped that we would be able to name the agent Steak Knife in the final report, the impact was significant on the trust and confidence of those communities and those victims. They feel, when you look at the backdrop of the earlier question about the obstruction to different enquiries, when I talk about Schedule 4 in the Troubles Bill, about us being asked to do 2 things with regards to passing information that aren't done in any other investigations, people start to think that this is just a continuation of being treated differently. And I think in the naming of Steak Knife sort of element of the Kenova investigation, the evidence is so overwhelming that in effect the public interest is now to name him. There is no doubt about that in my mind whatsoever. It's against all the it's against the measures of accountability and justice that I think we all stand for, that this individual who did these deeds has not been named by the state. And if you think, if anybody on a moral basis and a legal basis, anybody working for the state did serious harm or murder, and they were protected from criminal prosecution, today that would be absolutely unimaginable. It wouldn't be allowed. And it shouldn't have been allowed then. And by not naming him, it feels to me that some of the additional accountability that should follow, when I believe he will be named, ultimately I think he'll be named, whether that's in the immediate future through this Secretary of State or not. But those accountability measures need to come, because it feels to many families that he's not being named so that the government can hide behind the shield of NCND. So with all the things we're trying to do on legacy at the moment, all the warm words about giving information that's never been given before, they have got to demonstrate that they mean that. And by naming the agent steak knife, because of the context and the very unique circumstances of this case, which I think make it compelling, it will go a long way to providing people with some trust and confidence around this government and legacy.
Thank you, Chair.
Can I just keep you on Connie's point there about naming agent steak knife? And I hear everything you say about confidence and about transparency of the state, and I agree with that. But is there an issue then that you diminish confidence for people who are currently serving as informants?
Yes, it's a good question. And obviously I've only ever been really, most of my career anyway, in the covert policing space. So there's a couple of things I'd say about that. If you look at the interim report and the final report, it sets out very clearly that the agent steak knife was involved in the murders of a number of other agents. I think it's quite reasonable to expect that those agents and their families, and those agents took huge risks, would have expected to have been protected by the state. The behaviours that are set out very clearly in the interim report and the final report of this individual make it quite clear to me on both that legal and moral test basis that he should be named. Where we've had naming of agents before, Brian Nelson is an obvious one, who was also an agent for the Force Research Unit. The sky never fell in. Nothing happened with regards to the recruitment and the retention of agents. Gary Haggerty, Declan Casey. There are cases that on the face of it seem less serious, where we have either named agents or formally declared that somebody wasn't an agent. And I can tell you from all of my experience, this chill effect, if I can call it that, of people would not then become agents, I have seen no evidence of that. And it's had a covert policing, the Chief Constable of the PSNI, when we did a gist in the Sean Brown case, there is no evidence that that is the case. And I actually think by naming him and the accountability that would follow, we would actually show that we are looking after agents and demonstrating that we're learning from times where we got things terribly wrong. So for all the different ways that you can look at this, I find it hard to understand that there's a justification for it to continue. And even if I could just mention, in Iain's report, I think it's section 9, Iain really carefully sets out items with regards to the agent's steak knife, and I'm being very careful how I describe this, and information with regards to Freddie Scappaticci. Okay. And in that narrative, it sets out when the agent's steak knife was first revealed as an agent, which was by a journalist, Liam Clark. It sets out when Freddie Scappaticci was first connected with that named entity of the agent's steak knife by Iain Hurst. It then goes on to set out in the report very carefully how one of the previous general officers in command here, John Wilsey, was duped by somebody purporting to be a journalist, and it was Iain Hurst, and says, and it's publicly available, says that the agent's steak knife was Freddie Scappaticci. You've also got, in the Kenova investigation, an element where Freddie Scappaticci has said to his wife and a female associate that he was the agent's steak knife. You have a journalist, Sylvia Jones, who describes, who was responsible at the time for a documentary in which Freddie Scappaticci appeared, that a senior RUC officer told her that he was a senior agent. All of these things culminated in a solicitor, Kevin Winter, saying, all the dogs in the street, forgive me, I've not got the quote, know the agent's steak knife is Freddie Scaptici. None of that is any formal acknowledgement, nor do what I say now in any way give any indication as to the identity of the agent's steak knife. I'm simply saying what's in the report. But when people in society see all that, and we're still not confirming or denying the position with regards to the agent's steak knife, I think it creates a lack of trust and confidence in those of us who are charged by the public to deal with legacy and keep society safe. And it becomes frankly quite ridiculous. So I'm happy to speak to anybody who's got an alternative view. Ultimately, it's the decision of government as to, and we would never, by the way, Iain and I obviously are aware of the identity, we're aware of other identities of agents, but that was done on an understanding of confidentiality which we would never breach. We would not breach, we would always follow due process. That's why I've formally asked and written to the Secretary of State to address this issue in identifying the agent's steak knife.
Okay, thank you. Morris?
Thank you very much, Chair. Thanks very much for coming in and giving a presentation. It's good to see you again, Chief Constable. Your Kenova report is widely known that it covers the activities of one informer within the higher echelons of the IRA, and much attention has been drawn to the conclusion in that report that steak knife operations probably resulted in more deaths than lives saved. Would you agree that there's a risk that Kenova, when taken in isolation, could undervalue and misrepresent the contribution of informants and agents in their totality, who have infiltrated the IRA at all levels, from the bottom to the top, and providing intelligence and saving lives at the same time?
So it's important I say this, and I do it in the report. We owe a debt of gratitude, huge gratitude, to the security forces across the piece who performed heroically during the Troubles. Mm-hmm. And we owe a debt of gratitude to a number of agents who took unimaginably high risks to try to keep society safe and operated very properly. And the security forces who managed those agents operated very properly. And I make that very clear. In this particular case, because of the investigations of Operation Kenova, we know that didn't happen. And ordinarily, the application of neither confirm nor deny is something that courts will adhere to, because there is a quite proper assumption that the security force and any agents have operated within the rule of the law, have operated with propriety. In this case, that didn't happen. So I am very clear that without those very brave men and women who worked as covert human intelligence sources, routinely helping the security forces to keep people safe and keep society safer, we wouldn't be in a position now where I think we are, so many years after the Good Friday Agreement, and in a much different and safer society. But in this particular regard, for this particular agent, with the information that we know and the serious criminality that was involved, that's why both I and Sir Iain, and Sir Iain might want to make some remarks on this, have set out the findings that we have about this particular case.
Can I just add one point? And again, I agree with John that the observation you make about the contribution of value is unarguable. It's quite remarkable bravery for people who are trying to present information to allow lives to be saved and communities kept safe. But it also goes to one of the queries that the chair made as well. And my point is that I actually have a very strong view that the naming of the agent steak knife would actually support the principle of NCND, because any agent, any source has to know there are limits to that protection of anonymity that NCND provides, and rightly provides for some of the reasons that you outline. But it cannot be unlimited. It cannot be a grotesque abuse of humanity and violence and criminality that is so patently unlawful that allows that individual to keep on continuing that behaviour, knowing, if we don't name steak knife, knowing that actually my anonymity will always be protected. So in terms of how an individual operates, there must be limits, and that individual who acts as an agent or acts as a source must know there are limits. And if those limits are not breached, in this instance, I don't know where they would be, in this instance, in terms of the agent's steak knife. So my view is that not only is it the right ethical position, as again John has strongly outlined, but I actually think it would recognise NCND and clearly state that it's not an unlimited guarantee of anonymity, that you get past a line, as we have in this instance, well, rightly the public interest then it takes greater precedence over that protection of anonymity.
Chair, we have to keep in mind that it's the victims and the victims' families that are at stake here. I mean, I've lost a friend in a Dibby car bomb, a roadside bomb, and one shot in the back of the head in a seaside town. So the Troubles has impacted each and every one of us probably sitting around this table in some form or another. But to get to the bottom of legacy, do you believe that your operation, Kenova, can be rolled out as a precedent for investigation by the Irish state authorities into the alleged role of members of its security forces and government agencies in acts of terrorism perpetrated during the Troubles? Could that help the Irish government come to a conclusion on their role in the Troubles?
So the Irish government have publicly spoken incredibly positively about Operation Kenova, as has the British government, as have victims groups, has the victims. But Operation Kenova is the collection of learning from previous legacy investigations, which I mentioned earlier. And Kenova needs to, there are elements of Kenova that now I would do differently. And the Legacy Commission and anything with regards to structures for future legacy investigations in Ireland, anything that's going to follow the pillars that was put in place by Kenova, I think are really sound. And we engaged with the British government with regards to that first legacy bill that was written. I have to say I didn't recognise a lot of Operation Kenova in the structures of the ICRIR. I didn't. And I've said that because I've been asked the question, I've just been honest about it. But I think there is a determination within that commission, and there are some excellent people within that commission to get this right. Mm-hmm. And I think there is an appetite by this Secretary of State to listen to the different views and the concerns about that initial legacy legislation to make sure that the new Troubles legislation addresses a number of the concerns that are raised. And as we speak, the British and Irish governments are together, as I understand it today, and there is a need for both of those governments to come up with a shared approach to legacy. Iain will come in on this, but Iain has done a huge amount of work on the Dublin and Monaghan bombings. There are a number of issues with regards to information and activity of crimes along the border that we need the help of the Irish authorities with regards to investigations. So there has to be a way of finding a joint venture to make sure that whether you're north or south of that border, you have the confidence that there is a mechanism in place for you to get information about what happened during those cases. And I do generally believe there's a determination to achieve that position. And I hope that that's what happens. But Iain may want to talk about the South.
Again, I don't think we avoid any criticism of agencies in the South as well. There's a number of the victims and families that we've spoken to, certainly around the Dublin and Monaghan bombings, they had significant reservations about the British state. They had significant reservations about some agencies of the British state, but they also were incredibly critical of their own state agencies in the South, about the then response of An Garda Síochána, about the wider state infrastructure in terms of welfare support and other matters. And what I take from that is just the fact that regardless of whether it's in the north or whether it's in the south, there's no doubt that victims and families were significantly let down by state agency. There's absolutely no doubt about that. And I think, again, it sounds almost simplistic to say, but the first step towards progress is to recognise that and to accept that. And that's what, again, I think Kenova has shown, that victims and families have said, actually, you're the first people that have listened to us, have shown empathy, have been realistic about what we can achieve. We can't necessarily get a criminal justice outcome. There are some material that's lost, some answers we won't be able to give to you, but just to treat victims and families with dignity and with respect, and that will take the effort of everybody in the north and the south in that regard. So I do hope and I do believe that there are lessons for the agencies in the south as well as Northern Ireland and across the rest of the UK for what's come out of Kenova. I do think that.
Yeah. Can I just add something? Sorry, only because the security forces is the element there. It's very easy to criticise looking back at how these matters were investigated all those years ago. I joined policing in 1983. Policing in London was completely different in 1983. Here, because of the threat, because of the volume of murders that were occurring, one half of society here didn't have the confidence to speak to security forces, and if they did, there could be consequences for them speaking to security forces. The security forces were under such threat, they couldn't conduct inquiries because of the risk to them from paramilitaries on both sides that they would have wanted to conduct. And that's why legacy is so important now, to try and put in place an investigation, because some people have said to me, but this was investigated at the time, John, or there was an inquest at the time. Those investigations and those inquests never got the information that the families deserved for all sorts of different reasons. And that's why it's very easy to look back and criticise. To be a member of the RUC it was the most dangerous police force in the world to be a member of in the 1980s. There's a report about that. So this is wickedly difficult on all sides. I just think it's important, and we say it in the Kenova report, to put in the context of the time around some of these investigations.
Chair, thank you very much. It's important to seek closure for the victims' families. I think they deserve at the very least that. Thank you.
Thank you, Morris. John, you said in answer to Morris that you would do things differently if you were to commence Kenova today. What things would you do differently?
So, it's a good question, and I provided some stuff to the government about this when they were looking at the Legacy Commission. There are some elements with regards to activity, the information from the South. We ended up getting a statutory instrument, a legislative instrument to get information for the Glenangang series of offences, but that took some time. And I think we were far too slow, and there was significant frustrations with the families around making sure we got that engagement with those stakeholders. There were other stakeholders that we concentrated very much on the families. Some of this was capacity that I think before we actually started Kenova, we should have done more work with some of those stakeholders, support groups, to make sure that we heard from them about their experiences and their advice about how we should undertake the inquiries. Even with regards to the terms of reference of Operation Kenova, that terms of reference was agreed between myself and the Chief Constable of the PSNI, George Hamilton. We didn't speak to the families. We didn't speak any wider to any community groups, victims groups. And again, I think in the way that the government were criticised for not consulting over the legacy bill, and I said you need to consult widely, broadly, richly, to get everybody's perspectives around legacy, I think we just went into the investigation. Now, we did a lot to try and recover some of those, I think, shortcomings. But just as a brief set of examples, I think there's things that we should have taken more time to do before we actually started the investigations.
Okay, thank you. Brian?
Okay, thank you both for your answers so far and for your work on these important matters. In the interim Kenova report recommendations, it includes that the Republican leadership should issue a full apology for PIRA abductions, torture and murder of those that accused or suspected of being agents during the Troubles. There was subsequent statement from Sinn Féin's Michelle O'Neill, but public figures including Judith Thompson, the former Commissioner for Victim Survivors, have indicated that that statement by Michelle O'Neill would not equate to an apology under international law. The final Kenova report says ultimately it's up to families to decide on the sincerity of any apology. But for your own part, do you think that Sinn Féin leaders Mary Luke MacDonald or Michelle O'Neill should categorically apologise for what the IRA brutally perpetrated on families across Northern Ireland, including on their own communities, those within their community who were accused of working with the security forces, when in fact it was actually someone, and indeed some people, at the very top of the provisional leadership?
What I wanted to do firstly is acknowledge that Michelle O'Neill came out, I think it was the afternoon of the release of the interim report, and spoke publicly about the report, acknowledged the report and the victims. There are 10 recommendations in the report. None of the recommendations, in the way that I think I and members of the steering group, the governance board, the victims group, and the victims of the investigations, as we had all hoped, have been supported across the political sort of leadership in Westminster or here. There was a request for the acknowledgement by the British government of what had happened. That hasn't occurred in the way that David Cameron did with regards to Bloody Sunday. And the reason given by the then Secretary of State was ongoing legal issues. In Northern Ireland, there are ongoing legal issues all the time. Iain, I know, has done a lot of work to try to encourage all the people of influence to try to address the 10 recommendations, which were written very carefully, and they're incredibly achievable in bringing people together. So I think there's a call for those recommendations even now to be looked at by the executive and by government. And with this, the dawn of the new legacy arrangements before us, to use those recommendations as a platform to provide families, those who will want to go to a legacy construct with confidence, with something to suggest we've learned the lessons from Kenova. The sort of silence has been rather deafening. With regards to Judith's comments about the Sinn Féin remarks after the interim report came out, one thing about apologies, they need to be done really well. Ideally, they should be done once, and they have to be absolutely sincere. And I think it's right that they should be done in consultation with the families. So that's something that I've learnt during this process from the victim support group that we have in place. And Judith, I have to mention, was on the victim support group as well as being the victims commissioner here. She was on the Kenova victim support group. So listen, I think there's a lot of people in power, in influence, places of influence, who've got to do a lot more about those Kenova recommendations. And I know there was a call for arms to do that when Iain released his final report in December.
Can I just add a point on the recommendations, if I may? And I mentioned it in my very brief opening remarks about, Kenova is going to come to a conclusion. We are literally single figures, the number of people that are still working on Kenova. There's myself and a number of colleagues, and rightly so. The work of the final report's been concluded. There's a number of issues, although as John has already alluded to, not least of all, getting clarity from the Secretary of State on the naming of the agent stake knife. He has written to both John and I. John mentioned writing to him in his capacity as Chief Constable, and I wrote to him in my capacity as the Officer in Overall Command. He's also given an undertaking to update the House of Commons, because in a statement that the Secretary of State made at the launch of the final report on the 9th of December, he made a statement in the House of Commons that he would come back and address that matter there. So we cannot remove ourselves until those issues are properly addressed. But I do have a concern that the 10 recommendations that sit there, from the UK government issuing an apology to the leadership of the Provisional IRA and the Republican movement issuing an apology and a clear and unequivocal apology in both cases, that those 10 recommendations, there needs to be a continuing monitoring or ownership of them. And I do think it's people with the legitimacy of this committee and of this group who would continue to do that. So almost a respectful request would be, when Kenova finishes, as it will, please don't, if we can keep a focus on those 10 recommendations, I think that would be very important in the public interest.
Mm-hmm. Okay, one other question, if I can. Thank you, John, for making reference to the Kennego embankment bombing and your work on Operation Terma. I declared interest earlier that I am related to Paul Hamilton, one of the officers killed in that bombing. And I think that case is an example of where a fresh look at the evidence and re-interviewing of people led to a large number of evidential leads, and retesting of items retained using modern techniques has resulted in the extradition and charging of Martin Macaulay, who's currently on bail but has appeared in court. He evaded justice in Colombia as one of the Colombia Three by skipping that country, where he was passing on IRA terrorism techniques to FARC. But it is an example where justice can potentially be served. Could you want to say something more about the importance of the avenues of justice being kept open? And we know the passage of time is always a factor, but where there are evidential items that can be of assistance.
What I think is important to say is it's ever more difficult as time passes on to achieve a criminal justice outcome for legacy cases, just to be really realistic. The approach to Kenova was to try to get the information of what happened to the families so that we could answer their questions. Because of the incredible improvement in what we can do now forensically, which is, it is amazing what we can now achieve with regards to obtaining DNA, recovering DNA from exhibits. A fresh analysis of exhibits provided us with evidence that we were able to identify. That's an ongoing prosecution, so I don't want to say anything about that particular case at all, but what I will say, it does demonstrate that there are going to be occasions for the Legacy Commission. There are going to be occasions. And I think this will be almost entirely where there is forensic evidence, where there will be an opportunity for the odd prosecution. But I do think it's important that everybody understands that will be vanishingly rare. Okay. And then even to achieve a successful criminal justice outcome is incredibly, incredibly challenging. I think the focus of Legacy should be getting the information as to what happened to their loved ones for those families.
Okay.
Doug?
Thank you, Chair, and Chief Constable and Sir Iain, thank you for coming here today, and thank you for all you've done on this report, because it's incredibly important if we are going to reconcile ourselves going forward. I have to say that not naming Freddie Scappaticci as steak knife is farcical and quite embarrassing. It's akin to a Monty Python sketch, and I think you're absolutely right. It does impinge on trust and confidence. But so does the fact that having done this complex investigation and produced 29 files for the Public Prosecution Service, covering 38 individuals, and none of them went forward for prosecution, that also, I think, has an issue in regards to trust and confidence as well, because I'm in no doubt due diligence was done. Is the issue in this case, the fact is that intelligence information was inadmissible and couldn't be used in the courts, in which case was there not another way around this, that we could have done closed court sessions to be able to see that intelligence if it wasn't necessarily publicly admissible?
So I think, and I'll bring Iain in on this, there are a number of complex reasons. I set out in the interim report some observations, and one of the recommendations, one of the 10 recommendations that have been referenced during this committee hearing, was that the Public Prosecution Service review how they undertake the examination of legacy cases. And I identify in the report a number of concerns I had around how that process had been undertaken. I have to say that, as ever with regards to often in Northern Ireland, the resourcing and the funding that the public prosecution receive, and the director of the Public Prosecution Service will want me to say this, meant that he was incredibly challenged in being able to look at those cases as quickly as we wanted him to, and in the manner that we wanted him to, with regards to what you would ordinarily have is a very close relationship between the investigative body, a reviewing lawyer, and reviewing independent counsel, particularly with very, very serious cases. And I think if Stephen Heron were here now, the Director of Public Prosecutions, he would say, because of his demands on contemporary cases and risk to life cases where people could come to harm today, he had to make choices around priorities. So even the decisions on the Kenova cases took a very, very, very long time. And that's another thing that impacts on the confidence of victims in the entirety of the end-to-end system. With regards to the actual evidential issues, there are so many things that I would like to say about that wouldn't be helpful to get into today. There is a challenge with regards to hearsay evidence, because these cases are from so long ago, as to how we address that, because often witnesses are no longer alive. And I think in legacy cases, we could, in these particular cases, have taken a different approach with regards to hearsay, an approach that I have taken in courts in London, which has been supported by the courts. I think there's a nervousness about legacy cases here. They take a long time. They get huge scrutiny. And I think that leads to a certain amount of nervousness around making sure, and the threshold is a threshold, by the way, for a criminal prosecution, I accept that. But in life, sometimes you need to, I think, have a bit of courage around some of these cases where that threshold is there, and prosecution decisions could and should, in my view, have been made. And there's one particular case that I just ask you to look at. It's set out in the interim report, it's mentioned in the final report, and it was the file with regards to the perjury. And I said at the launch of the Kenova final report, when Iain published it, I made clear that the person who that file related to was Freddie Scappaticci. By the way, that's not breaching any NCND issues at all. Again, it's just setting out the facts. And those sorts of cases are difficult to prosecute, but I'd point you at what the Director of Public Prosecution said in his public commentary about that decision. These are challenging cases, Doug, to prosecute, legacy cases. And I think the overall position from the prosecutor, and I understand this, is they've got to be even more confident than beyond all reasonable doubt to take those cases forward, because there's such legal challenges here in ways that I've not seen before, in ways that I've not seen before in the criminal justice cases in England and Wales. And indeed, the time that those cases take is much longer, as you know, than they would in England and Wales, even though I think they're now having challenges around some of their criminal justice times. So there's a plethora of issues with legacy cases. A lot of it, I think, comes down to investment. Some of it comes down to mindset. And I would still advocate that legacy cases that go to the Public Prosecution Service should be subject, the process should be subject to a review to provide families, victims, witnesses with confidence that they are being considered in the very best way they can, and that the prosecutor has got the resources that he needs to deal with those cases.
Again, the observations you make on the frustrations, I think, that certainly us within the investigative team and victims and families would feel about the fact that there was non-prosecution decisions made, I think are valid ones. I mention it in the final report, and there's a part of the series there where we talk about evidential challenges. And the only point I would add to what John's made is, this principle of best evidence. So, as you would know, the fundamental, can you get the principal source, and that source is the best place. And when I say a source, I don't mean an informant. I mean a document, the original transcript, the original recording. And if that doesn't exist, you then go on to secondary and tertiary pieces of evidence. And by definition, they are weaker than primary pieces. So in this instance, what would have been very powerful evidence would have been the contact forms between the agent's steak knife and his handlers. And unfortunately, what we found, that a lot of the contact forms that, for example, Lord Stevens had when John Stevens carried out his work, had actually been destroyed by the time Kenova came to his work. Now, we make no comment on that. That might have been entirely legitimate through retention of material and whatnot, but it did mean that thereafter to go and try, as you said, to convert some of that material into an evidential format, we then had to go on to secondary pieces, which would be reports that have been produced from those contact forms. And again, by definition, from a prosecutor, they see them as being weaker than that original primary document. So that was undoubtedly a factor, I think, in the PPSNI's decision making. But a frustration about a lack of prosecutions, I think, is one that, I think we're quite clear in Kenova that's a frustration that we also had.
Yeah, and if I could just follow up on that in 2 points, please. First of all, Chief Constable, you mentioned the whole fact is that they wouldn't allow the hearsay, yet they've allowed hearsay in other legacy cases, and to not then allow it for the Kenova series of files. seems slightly odd. So there's no continuity there if that's what the PPS are doing, allowing it for some legacy but not for others. And the second, if I could ask you just on the same point before I go to the next, the 29 files, they remain open files, so if more evidence come, can they be resubmitted? Are these closed off now? And that's just, what status do these have now?
Can I just mention only, sorry to interrupt you, I think it's important that the Director of Public Prosecutions is able to answer some of these questions, because the individual matters, I wasn't part of that decision-making process, and there may be very valid reasons. And he's an incredibly capable director as to why those decisions were made that I can't give you today. So that's an important point to make. With regards to, what was the second element of your question? Sorry.
It's what's the status of those 29 files now?
Yeah.
What happens with them?
So obviously you can only consider somebody, and Iain will probably want to come in here because he would have been speaking to the director more recently than I. You can only consider files if somebody's alive to be prosecuted. So that's the first point. You will be aware that a number of those files were against offending Freddie Capitici, so those files can no longer be considered. I think with the onset of the new legacy arrangements, and I think some of the families I know that I've met through the Kenova journey will probably go to the Commission. It is entirely possible that they could find new information, and if that's the case, provide that to the Director of Public Prosecutions for consideration around a criminal justice outcome. So the files per se, the decisions have been taken on the files of the people that are alive, and we've had those results. A number of files that decisions hadn't been made on, and Iain might correct me on this, because of the passing, the death of Freddie Capitici, no decisions were then made on those files. The decisions that they did make on the files when he was alive were for non-prosecution. Okay.
I don't know, if I'm being really candid, the full answer to your question, and I'll explain partly why. Because under the Legacy Act, there was that cut-off point for a decision round about prosecutions, and actually one of the last things that the PSNI did was take the prosecution decision on Kinnigo Embankment. So that was 2 weeks before the cut-off date, and that was a very, very important milestone. The new Troubles Bill, which is still going through Westminster, how that addresses it in terms of cases that had previously been submitted to the DPP in Northern Ireland, and what can then be done with them, I genuinely don't know. And I think that'll be another issue as the Troubles Bill goes through Westminster. I think there's still an awful lot of formulating to be done around that to allow ICRA to move to what I think they're going to call the Legacy Commission. But as somebody who's studied it, I'm not part of ICRA or the Legacy Commission and looked at it, I still think there's a fair bit of uncertainty on some of these issues. And I can't add to that, I'm afraid.
Well, I don't disagree. Can I just move then briefly on to Up Denton? Because Up Denton, which I think is important in the Glen series of crimes, and it was clear that where there was individual collusion, individual members, there was no higher state collusion in regards to that, which was fine. And whenever you were answering questions earlier, I think it's yourself, Sir Iain, you seemed to animate that you had good access to the victims of the Dublin Monaghan bombing, and were able to speak to them and get information in regards to that, which is very positive. And I think yourself, Chief Constable, you says that eventually, having done the statutory instrument, you managed to get information from the Irish Security Services. But can I ask, was that information that came from the Irish Security Services, was it redacted before it came to you? Did you get clear, full information and redacted after investigation, or was it redacted before investigation? There's a very defining difference there.
When we did get it, and as you know, in the south, it comes through An Garda Síochána. They're both the police service and the security agency. Where we did get it, and it did take the intervention of the piece of secondary legislation to allow us to get it, it was what they had. But they didn't hold, in terms of volumes, they didn't hold an awful lot. And some of the material was material that had actually come from the north, if you like. So it was material that the RUC had been provided. And again, John's point about, 1974 and what was happening at the time and the pressures and the demands that were on, it wasn't archived or structured or in a kind of auditable position, if you like, that one might have imagined. But again, it's partly to do with the past and the historical challenges round about that. But the information that we got, was what they held, undoubtedly. I do think that you mentioned the Dublin Monaghan families, that our ultimate findings that the attacks were carried out by the Belfast Brigade of the UVF. And that's based on our professional assessment and intelligence and information that we've seen. And it was a review. This was not an investigation as such. We didn't use coercive powers of arrest or other things that you would do in an investigation. But this very, very deep review did point to that fact. A lot of those families had held for many, many years a contrary view to that. Their view, and supported by third sector support groups and other agencies, was that this was not the responsibility of the UVF. It was actually the British state had to sit behind it because it was the nature of the attack and assessment of capability. But actually our work around this really pointed directly towards the Belfast UVF. Now, the Belfast UVF claimed responsibility for it in the early 1990s. So, this was not wholly contrary to what had been expected. But the reason I make that point, or not been expected for some people, but it was not what the families had clung to, if you like, their view. So I mention it in the final report that at times our view is we go where the evidence takes us. We go where the evidence and the facts takes us, and at times that can actually mean delivering messages to victims and families is what is different from what they expected, or actually even at times different from what they wished. But that's our duty and our responsibility is to tell it as it is. But because I think of the approach that John established, the relationships that we had, the fact that we were being very, very frank and honest with the victims and families, I think there was a level of respect for that. And that again allows them to say, well, Kenova through Operation Denton have looked at it. That's their conclusions. Now, again, people may still have concerns, and I read articles about observations around that. But our view very strongly was that this was the Belfast Brigade of the UVF, a horrendous, terrible attack. But we didn't see any involvement of British state agencies in that. And if that's our findings, we just have to express them very clearly.
Yeah, and I think, Susan, that's quite clear. It's difficult for families to hear that when they've for so long been told something is slightly different. But I guess one of the reasons I asked the question about the engagement with the Irish security services and the information that you got from them is because we're now about to go into another legacy mechanism where we're looking to get information from the Irish security services. And if there's no mechanism to check to make sure that you got everything that was available, because as you said, Susan, you got what they had, but there's no mechanism to check that was all they had. I think that's a concern as we go forward. And why you can't give me an answer now, it's clear, and I wouldn't necessarily expect you to have to give me an answer now, but it just gives me something to think about as we look to the new legacy mechanisms coming in and where the fault lines may be in regards to if that makes sense.
I do. I mean, I recognise that. It comes back to one of the earlier points about how do you know you've got everything?
Yeah.
Do you ever know? And actually, that's why both John and I this afternoon have stressed that information retrieval and recovery is crucial to the trust and confidence of any legacy process going forward. I would say though that one of the early statements I think from the Irish government was to provide additional funding to assist An Garda Síochána to set up a legacy unit, maybe to address some of the shortcomings in information retrieval and information archiving that was identified through Kenova. So I know that's a commitment I think that is in train. So some grounds for optimism, I would hope.
Can I ask a very, very brief question? This is my one criticism I'm going to say to you. Why did you decide to use the term agent? Because an agent is formally recruited and formally trained, whereas a covert human intelligence source is really what we're talking about in regards to state knife. Was there a reason why we decided to use the term agent as opposed to human source?
I think. Sorry.
Sorry, it was just Chiz was used as well for Norm. Sorry.
Yeah, no, I think, Doug, I have to check on this. I think it was inherited when the terms of reference were set, and it came originally from the Director of Public Prosecutions. The term used, and they were called 35-5 referrals under the Justice Act of 2002 from the Director of Public Prosecutions, who can direct the Chief Constable to conduct an investigation where the Director believes there's been offence within the jurisdiction of Northern Ireland. And the terminology in those 35-5 referrals was agent. So it was a legacy, I think, into terms of reference. That's what I recall it as, yeah. I can check that.
No, that's fine. I mean, it's not important. I was just trying to get an idea. Sir, Charles, thank you.
Can I just thank you for both Iain and John for the way you have led this presentation, and you have kept the focus on the victims, so I'd thank you, echoing Connie's sentiment there too. I have one more question for you, and I suppose, John, you wear two caps. You were the lead investigator, if you like, for Kenova, but now you're the Chief Con, and surely there's an overlap there with regards to even your experiences and your knowledge now, having experienced Kenova. Given the fact that informants, agents, covert intelligence sources, call them as you will, were vitally important throughout the Troubles because of the intimidation, the coercion used by terrorist outfits. It was really the only way in at times for the PSNI and the RUC to actually investigate and bring people to justice. And the fact that the security services actually, if you like, strangled the activities of the terrorist organisations, brought them to their knees to end the terrorist campaigns. Anything in your experiences and your desire to see disclosure to the families and victims out there, is there anything that then now changes your operational sense of the PSNI and how you actually use informants and agents now and in the future?
So, do you know what? It's a really insightful question. I do just want to add something to a comment that you made there. The Internal Security Unit of the Provisional IRA deployed the worst possible violence in even an era of unimaginable violence. And they deployed it, by the way, to, and this has always been denied, but this is the case, I've spoken to the victims, they deployed it against family members, children, the elderly, people with learning difficulties. It was unimaginably awful what they did. And it was and they weren't interested, in my view, in whether somebody was an agent or not more often. It was about deterrence, what they would do to subjugate the community, to intimidate the community, to stop any interaction, liaison with the security forces of any kind. And that's important that I say that. During the period of the Troubles, the security forces operated without any legislation or formal framework giving them the necessary guidance, parameters, direction, training that was required in such a wickedly difficult environment. They actually operated under Home Office guidelines that were written in 1969 that provided what there was around any direction and instruction about how to deal with agents, chiz, call them what you will. And it's in the reports, I can say categorically that they were asking for help from government to give them a framework. and that didn't happen. And that was referred to by other people who investigated legacy, including Lord Stevens, and De Silva mentioned that to me. So that's an important point to make. So at that time, I think it's reasonable for me to say this, that agents were recruited who today would not be recruited because of the nature of who they are, their characteristics, their criminality. There are now a number of pieces of legislation, oversight mechanisms that provide a level of checks and balances that would prevent somebody such as Steak Knife being an agent. So there is a very definite difference with regards to the recruitment and management of agents CHIS today from what existed through quite a protracted period. So there'll have been changes within that period. So to answer your question in short, we would not expect somebody of that type of behaviour in any way to be recruited as an agent now. It would simply be unimaginable. It wouldn't happen.
Okay, thank you very much for your time here today. No other member has indicated to ask questions, so thank you for your time. It's been a long session. We thank you for that, and your answers have been very thoughtful here and very insightful. So thank you very much, Sir Iain and John. Thank you.
Thank you very much. Thank you, members.
Okay, members, we will now move on to agenda item number 5 to 10, SRs on court fees. Can I advise members that the next 6 agenda items concern individual statutory rules laid by the Department of Justice, all in relation to uplifts in court fees. The SRs are made under powers conferred by section 1161 of the Judicature Northern Ireland Act 1978, with the concurrence of the Department of Finance and after consultation with the Lord Lady Chief Justice as required by section 116(1) of that Act. Can I inform members that each of the rules are proposed to come into operation on the 1st of April 26 and cover the increase to fees over a 3-year period. They propose amendments to their respective fee orders that will provide an initial increase of 5%, followed by a further increase of 2% on 1st of April 27 and a final increase of 2% on the 1st of April 28. The rules are not subject to any procedure. However, the Department states that in making these SRs that it has undertaken to comply with the 21-day rule. Can I inform members that the relevant consultation, impact assessments and section 24 information on each of the proposed rules can be found in the clerk's memo at pages 189 to 193 of the meeting pack. Members may also wish to note that on the 3rd of March 26 the Northern Ireland Courts and Tribunal Service published a response to a public consultation on proposed changes to court fees, including the annual increases. The copy of this report is available at pages 215 to 280 of the meeting pack for information. The Department has also advised that there have been no changes to the policy content of any of the 6 SRs since the SL1s were considered by the committee on the 27th of November 25. So can I advise members then that we will now consider each of the individual statutory rules in turn, which is what we'll need to do. Agenda item number 5 then is SR 2026/34, the Judgment Enforcement Fees Amendment Northern Ireland 2026. Now I refer members to page 194 of the meeting pack. Can I inform members that this rule will amend the Judgment Enforcement Fees Order Northern Ireland 1996 to implement inflationary increases to existing fees for the delivery of business in the Enforcement of Judgments Office. Can I ask members if they are content to note the stat rule or if any further information or clarification is sought at this time? No? Okay. Agenda item number 6, SR 2026/35, the Court of Judicature Non-Contentious Probate Fees Amendment Order Northern Ireland 2026. I refer members to page 282 to 292 of the meeting pack. Inform members that this rule will amend the Court of Judicature Non-Contentious Probate Fees Order Northern Ireland 1996 to make inflationary increases to existing fees for the delivery of non-contentious probate proceedings in the Court of Judicature. Can I ask members if they are content to note the stat rule or if any further information or clarification is required. Okay, content. Agenda item number 8, SR 2026/37, the Magistrates Courts Fees Amendment Order Northern Ireland 2026. Refer members to page 313. Did I miss one? Did I?
We can go back to it.
Did I miss that one? Right, okay. Well, we'll do this when we're on it. Item number 8 then, can I refer members to page 313? Can I inform members that this stat rule will amend the Magistrates Courts Fees Order Northern Ireland 1996 to implement inflationary increases to existing fees charged with the delivery of civil and family proceedings in the Magistrates Courts and prescribe new fees. Can I ask members if they are content with the proposal for the statutory rule? Okay, then we go back then, my error, agenda item number 7, SR 2026/36, the County Court Fees Amendment Order Northern Ireland 2026. We refer members to go back to page 294 to 311 of the meeting pack. Can I inform members that this proposed rule will amend the County Court Fees Order Northern Ireland 1996 to implement inflationary increases to existing fees for the delivery of civil and family proceedings in the County Court, as well as prescribing new fees in the Small Claims Court. So can I ask members if they are content to note the statutory rule? Content. Agenda item number 9 then is SR 2026/38, the Family Proceedings Fees Amendment Order Northern Ireland 2026. Refer members to page 334 to 350 of the meeting pack. Can I inform members that this rule will amend the Family Proceedings Fee Order Northern Ireland 1996 to implement inflationary increases for the delivery of business in respect of family proceedings, as well as prescribe a new fee for an ex parte application to a judge in matrimonial proceedings for an injunction. So can I ask members if they are content to note the statutory rule, or if any further information is required? Okay, note. Agenda item number 10 then, SR 2026/39, the Court of Judicature Fees Amendment Order Northern Ireland 2026. Now refer members to page 379 to 383 of the meeting pack. Can I inform members that this rule will amend the Court of Judicature Fees Order Northern Ireland 1996 to provide for inflationary increases to the majority of existing fees for the delivery of civil and family proceedings in the courts? Can I ask members if they are content to note the statutory rule, or if any information is required? Note. Okay, thank you. Agenda item number 11 then is Criminal Justice Sentencing Bill, pre-legislative scrutiny, correspondence 11.1, an individual, proposed victims' rights and sentencing amendments. Can I refer members to page 379? I'll get this up myself. 379. Can I inform members that the committee has received correspondence from an individual following their engagement with the Victims Commissioner designate? The individual has asked the committee to consider a number of amendments to the sentencing bill as part of the scrutiny of the legislation. Can I remind members that we will be considering the plans for committee stage scrutiny in the bill in the coming weeks, which will include how the committee may wish to engage with individuals who have requested to meet with the committee on various matters relating to this bill. So can I seek members' agreement to note the correspondence at this stage and to consider it further during scrutiny of the bill at committee stage? Agreed. 11.2, Men's Alliance NI request to meet committee. Can I refer members to page 382 of the meeting pack? Can I inform members that the committee has received a request from the Chair of Men's Alliance Northern Ireland to meet with the committee to discuss issues that male victims of domestic abuse face, and also concerns on sentencing for female perpetrators of domestic abuse. The correspondence also requests that the organisation be advised of any calls to evidence in the area of domestic abuse, especially of males. Can I seek members' agreement to note the correspondence and advise that the committee would welcome a formal response to its call for evidence on the Criminal Justice Sentence etc. bill when it is launched? Agreed. 11.3, Marie Collins Foundation, a request to provide evidence on the Criminal Justice Sentence etc. bill. Refer members to page 383. Can I inform members that the committee has received correspondence from the Marie Collins Foundation requesting to be included on the email list for the call for evidence on the sentencing bill? The committee had previously agreed on the 26th of June to invite the Marie Collins Foundation to provide oral evidence on the forthcoming sentencing bill. So can I seek members' agreement to add the Marie Collins Foundation to the committee's list of stakeholders who will be directly notified of the committee's call for evidence on the bill, and invite it to submit a response?
Agreed.
Okay, members agree. You can see how we're going to get a lot of interest with regards to the sentencing bill. Agenda item number 12 then, Victims and Witnesses of Crime Bill, pre-legislative scrutiny, correspondence 12.1, Department of Justice response on Kiva's Law amendment. Can Can I refer members to page 385 to 388 of the meeting pack? Can I remind members that at the meeting on the 19th of February, the committee considered correspondence from the Department of Justice in relation to the potential inclusion of Kiva's law in the forthcoming Victims and Witnesses of Crime Bill by way of a committee amendment. Members agreed to respond to the Department to advise that while they are strongly supportive of seeing the provisions of Kiva's law coming into legislation, the scale of policy development and legislative expertise required to do so robustly is beyond the committee's current capacity, and members are of the view that the Department is significantly better placed to conduct this work. The committee also requested information on policy development work to date and for an outline of the work required for the Department to take this forward. Can I inform members that the Department has responded to the committee's correspondence to state that the Minister's view remains that the Department does not have the capacity to progress this work, but she remains supportive of the Justice Committee bringing forward an amendment. The Department's paper advises that to date it has not conducted any detailed policy work on the matter, that the cross-cutting nature of what is proposed with Kiva's law would require input from colleagues within various Department of Justice business areas, as well as other departments, notably DFI, which has primary responsibility for road safety. Engagement with the UK Government would also be required, given that social media is a reserved matter, also on the type and extensive scale of work that the Department anticipates would be necessary to deliver such provisions effectively, and lastly, that contrary to the correspondence from the Infrastructure Minister to the Committee for Infrastructure, the Justice Minister did not advise families at the roundtable discussion convened by Road Victim Support NI that the Department of Justice would take the lead on the legislative stand of this work, but she did say that she would be supportive of the committee bringing forward an amendment to the Victims and Witnesses of Crime Bill. Members, I think we all want to see Kiva's law in legislation, but I think for the Department to put the burden of that onto the committee when the committee is this size and the Department is this size, with all the connections that they would have to the UK Government with regards to social media law, with regards to all of the different various departments within the Department of Justice, with the liaison that they'll have to do with regards to DFI, with regards to road safety, I think we need to be robust here in that we want to see this done, but we, as a committee, have not the capacity nor have we the scale compared to the Department of Justice. To me, it's that simple. Now, I'm saying all this, and it's every member's prerogative to bring forward an amendment at any given stage of a consideration stage. So someone might bring forward Kiva's law as an amendment as a private member. So I really do think we need to stress the Department of Justice that we really want to see this in, but we really need the Department to pick it up and work with it. What's members' views?
Agreed.
I mean, I've said before, I just think this is a more complicated matter. We all know what we want to avoid, in that people taking and sharing images of literally people lying injured on a road,
yep.
Or having been killed. But there's complexity in this, people take an image of an accident, not knowing what has occurred or what they think might be something else. So there's a lot of detail. We'd need to know what's happening elsewhere in other jurisdictions. And I quite frankly, I think the Department should be taking it forward, and we're supportive of that. We've indicated that, and certainly within the remaining time of this mandate. We often hear about legislation done badly can put us in a worse place than putting it back until there is time to do it properly, with unintended consequences. So I think responsibility rests with the Department. I think they should seek to advance it in some way.
We're here to scrutinise the Department, but we're also here to support and assist where we can. So I think we can support and assist the Department with their work with regards to Kiva's law. I think that would be a reasonable stance for the committee to take. Any other views?
What do we do, Chair, if there's an impasse on this? If they say no, absolutely not, we're not going to, and we still want it, what's the outcome? What's our likely outcome on this?
Yeah, I honestly think that this will come to the floor of the Assembly Chamber, and a private member will bring an amendment. And it will be then up to the department to justify whether they support that private member's amendment or not. And I've been in that place many times where I brought forward amendments to many bills where the minister, no matter who the minister is, tells me, oh, we haven't done consultation on this, we haven't done due diligence on this would be irresponsible for you to move this amendment. And then it's up to the member whether they move it or not. But that places the onus on the member. But the thing is, the department, I believe, should have the time, should have the capacity to do work on this in the interim in case that very thing happens. I think we, as a committee, have to protect ourselves with regards to our capacity, our role, and with regards to legislation and what we can do and can't do in the time available.
And Chair, if it does go to a private member bringing it forward to the floor of the chamber, then I take it we as individuals will vote on that. That's not, although we all want it, that individual who brings it forward may not have done the due diligence rightly, you know.
And that's the danger with every amendment that every member will and could and should bring. That's part of the legislative process, you know. But I think we can go back to the department and say, look, we're here to assist and support. So you do the work, Minister, for fear of this coming in anyway through an amendment from a private member. And we're here, we stand ready to assist you in that, in helping you to bring forward an amendment to the bill. You know, I think that's basically where we're at. Because I think none of us here, every one of us wants to support this, Kiva's Law. I think we recognise the concept, but a concept is completely different to the text of a clause in a blue bill, and this is where we have to be careful.
You, Chair, put it back to the department with an indication that we would support
and assist where we can, but it's really up to the department to bring forward something of significance like this. Members agreed?
Yep.
Yeah. Okay, thank you. Moving on then. Kathy, are you clear there just before we move on?
Absolutely, and I mean, after the department comes back and it's still the same position, then I mean the committee can seek procedural advice on potential options that might be open then as well at that point. But we can manage that at that time. Okay,
members agreed then. Okay. Agenda item number 13 then is the Department of Justice 5-year Equality Action Plan and Disability Action consultation on draft Department of Justice written paper. Refer members to page 393 to 472 of the meeting pack. Can I inform members that the Department of Justice has written to the committee to advise that as part of its statutory duties under Section 75 of the Northern Ireland Act 1998 and Section 49 of the Disability Discrimination Northern Ireland Order 2006, as amended by Article 5 of the Disability Discrimination Northern Ireland Order 2006, the Department is required to have in place an Equality Action Plan and a Disability Action Plan. The Department has provided the Committee with a copy of its draft Equality and Disability Action Plans for information, as well as an audit of inequalities 2025 to 2030, recently coordinated by the Department's Equality Officer. The Department has also advised that in line with the DOJ's equality scheme, a public consultation is being launched on both draft action plans. So can I ask members if they're content to note the paper or if any further information or clarification is required? Did I miss something else? No?
Yeah.
Sorry.
I'm okay with that one.
So are members agreed? Sorry.
Just in view of the Department for Infrastructure's interest in the Kiva's Law, if members, just to get agreement to forward the Department's response to that committee for information.
Agreed. Sorry, that's me slipping up again.
There's a lot there.
Agenda item number 14 is domestic abuse in private family law proceedings, a raised written paper. 14.1. Can I remind members that at the committee's strategic planning day on the 25th of September 2025, members agreed to commission the Assembly Research and Information Service to conduct a literature review into aspects of domestic abuse and private family law proceedings. Ciara, I think this is one you were exercised about. Can I inform members that the raised paper is now available for members at pages 393 to 472 of the meeting pack, and it provides an overview of the current academic research relating to domestic abuse experienced by adult and child victims and survivors engaged in the family court system. Could I ask members if they wish to receive an oral briefing on the paper from the research officer? Sorry, Connie, you want to?
Yeah, I think that's a good idea, Chair. I'd like an oral briefing on this, and I was going to ask if we were doing an oral briefing, could we also maybe include in that committee session the Commissioner for Victims of Crime in Northern Ireland, who recently launched a report, Totally Invisible, which focuses on the issue of victims and survivors of domestic abuse engaging in the family courts. I think this is something that has been raised with the committee several times. I think it would be good if we could look into it and do a session on this.
Yeah, Cathy, you want to come in?
No, Chair, that's just what I'd mentioned to you this morning, a potential.
Yeah, that's fine.
Could we also send the report to the Minister and asked for a response from the Minister in relation to the number of key areas that have been identified, which we have previously discussed at committees?
Do you want to maybe even extend that to Minister of Health and Minister of Finance too?
Yep.
Considering they have a hand in this with regards to family law. Is that okay? And ask for their commentary on it. Okay. Any further actions at this stage, or will we wait to the presentation till the research officer speaks to the paper?
No, but just to highlight that they've obviously got that summit on Friday the 27th. Members have all been invited to. Yeah,
for sure. Okay, then we're okay to park this at this stage till we see what comes back, and we'll get that presentation into the forward work programme. Agenda item number 15 then is correspondence. Can I inform members that there is a correspondence memo on 15 items of correspondence at page 554 to 680 of the meeting pack? Can I advise members that I will draw their attention to 10 of the items of correspondence? 15.2, can I inform members that the committee has received a response from the Executive Office in relation to the eligibility for awards for the Troubles Permanent Disabled Payment Scheme and the role of the Victims Payment Board. Can I remind members that at its meeting on the 4th of December, the committee had agreed to write to TEO for clarity on whether changes to the processes and implementation of the scheme to address unintended consequences might be made locally by the Department, or if they can only be made via legislation at Westminster. Can I inform members that the Executive Office has advised that such changes are made via Westminster? The TEO has no power to amend the Victims Payment Regulations 2020, as the power to amend rests with the Secretary of State. Can I seek members' views on writing to the Secretary of State to outline the committee's concerns and ask what consideration has or will be given to amending the regulations to deal with unintended consequences? Yeah, I think this is one that Patsy had raised too, although Patsy's not here today unfortunately, but are members content? Yeah? 15.3, can I inform members that following a recent oral briefing that the TEO committee held with the Clerk of EU and Interparliamentary Affairs, a number of issues were raised in relation to the Windsor Framework and other EU matters. The TEO committee has written to all statutory committees to ask for an update on issues identified or discussed in relation to the Windsor Framework and wider EU matters. Can I remind members that the Windsor Framework was referenced in oral and written evidence on the Justice Bill from the Northern Ireland Human Rights Commission, and the committee wrote to the Department on this matter. So can I seek members' agreement to respond to the Executive Office Committee, providing an outline of the committee's consideration of the Windsor Framework in the context of the Justice Bill? So can I ask members if there are any other matters that they wish to include in that response to the TEO committee? Are you happy and content just to leave it the way it is? That's the only time we've really rubbed up against the Windsor Framework. Okay. 15.5 then, refer members to page 564 of the meeting pack, which contains an inspection report by Sagini into the use and operation of special measures in Northern Ireland's criminal courts. Can I inform members that the report examines how special measures, adjustments to investigative and court processes designed to support vulnerable and intimidated witnesses and victims were identified, delivered and monitored across the Northern Ireland criminal justice system, and includes a number of strategic and operational recommendations. So can I seek the members' agreement to ask the Department of Justice, the PSNI and the PPS for the response to the report's findings and recommendations? Agreed. Can I also remind members that the committee is likely to hear from Sir Ginny on the forthcoming Victims and Witnesses Bill, which may provide an opportunity to explore some of the issues raised in this report. Agreed. 15.7 and 15.8. Can I refer members to page 639 to 645 of the meeting pack, which contains responses from the PSNI and the Policing Board to views that the committee had agreed to seek in relation to relevant provisions within the Adult Protection Bill currently being considered by the Committee for Health. So can I seek members' agreement to forward both the PSNI and the Policing Board's responses to the Committee of Health to inform their scrutiny of the bill, which is at a similar level to where we are with regards to our Justice Bill. So are members agreed? 15.9 then, can I refer members to page 649 to 651 of the meeting pack, which contains a forwarded letter to the Justice Minister from Pam Cameron MLA requesting that the Minister meets with the McCollum family to outline their experience and concerns in seeking justice for Iain McCollum, who was tragically killed at McKinstry Biomass in Newry on the 24th of January 2022. The McCollum family are particularly concerned about delays in court proceedings due to the ongoing strike by the Criminal Bar Association. The member has expressed that she would appreciate any help the committee might offer on the matter. So can I seek members' views on responding to advise that it is sympathetic to the issues raised, but it won't be able to get involved in individual cases. But I think that we can write to the Justice Minister just to ask where cases like Iain McCollum's death sit currently in the system, given the barrister strike, but given the fact that some cases, like the other cases that have been allowed to go through, the Chloe Mitchell case for one in my own constituency, where the Justice Minister met with that family, and I suppose it's only right that the McCollum family would then ask, well, you know, when can we see justice? So could we write to the Justice Minister to seek her thoughts on cases like Iain McCollum's? Yeah, and others, because there's mountains of cases. There's over 100. So is that okay?
Forward the correspondence on.
Yeah, but we were copied in. So
she's written directly.
Pam Cameron has written directly to the Justice Minister. So it'll be up to the Justice Minister to respond to Pam, and hopefully that they can meet with the family. But we would write then just in a more general, broad sense with regards to the Iain McCollum's case, but then the countless others that's stuck in the system. Members content? Cathy, are you content with that instruction?
Yes,
15.11 then, can I refer members to page 660 of the meeting pack, which contains correspondence from Nina Briggs to make the committee aware of research and work that she has been conducting with other departments and the APG on modern slavery and sexual exploitation to better understand and provide empirical data in relation to anti-immigration unrest and aspects of modern slavery and the sexual exploitation of ethnic minorities in Northern Ireland. In her correspondence, Ms Briggs has offered to provide the committee with either a written or oral briefing on her research if members would find it helpful. So can I ask members if they're content with asking Nina Briggs to provide the committee with written material in the first instance, and members then can consider further once they've had the opportunity to consider the written paper. Agreed?
Agreed.
15.12, can I refer members to page 661 of the meeting pack, which contains correspondence from an individual and the Office of the Police Ombudsman, which the individual has forwarded to the committee. The correspondence relates to a report by the Police Ombudsman on investigation of the PSNI's response to dealing with vulnerable persons commenced in March 2023, which has still not been published. So can I seek members' views on whether the committee wishes to write to the Police Ombudsman to ask for an update on the status of the report and when publication can be expected? I think there's a confidence issue here and would like to see reports published in a timely manner. So are members content with that? Okay. 15.13 then, refer members to page 665 of the meeting pack, which contains correspondence from an individual seeking clarification regarding the Police Injury on Duty scheme and the Committee of Justice oversight of its review. The correspondence requests information on a number of questions, and the requests for information related to the committee's scrutiny of the review of the scheme. So could I seek members' views on asking the Department for a response to questions 1, 2, 4 and 5 of that correspondence? Members agreed? 15.14 then, can I refer members to page 666 of the meeting pack, which contains an invitation from the Northern Ireland Survivor Council to an expert insights event in the Long Gallery on Thursday the 30th of April. So can I advise members that if they wish to attend, they should respond by the 31st of March via the email address in the correspondence. Can I ask members then if they're content to note the other items of correspondence set out, or is there anything anybody wants to comment on? No? Okay. Agenda item number 16 is the forward work programme. Can I inform members that the latest draft of the committee's forward work programme can be found at pages 682 to 687 of the meeting pack? Can I remind members that the committee agreed last week that it would be helpful if the Permanent Secretary could attend committee to further discuss the proposed expansion of out-of-court proposed disposals. That oral evidence session will take place on the 26th of March. So can I seek members' agreement to the forward work programme?
Yep.
Okay, thank you. So agenda item number 17 is chairperson's business. I can advise that I have no chairperson's business. Agenda item number 18, any other business. Can I ask members whether there are any items of business they want to raise? No? Okay. So agenda item number 19, time, place of next meeting. Can I advise members that the next meeting will take place on Thursday, 19th of March 2026 at 2 p.m. in room 30, Parliament Buildings? Okay. Can I seek members' agreement then for the meeting to move into closed session to continue committee deliberations on the Justice Bill, departmental amendments and potential committee amendments? Yep. Agreed?
Agreed.
Committee Room 30. Sound. 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 Committee Room 30, 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 Sound. Committee Room 30. 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 Sound.